Welcome to the Veterans Legal Lowdown, a podcast about veterans' appeals and claims from CCK Law, the nation's leading veterans law firm. Today, we're going to be talking about a few different topics. First, we're going to discuss claims based on military sexual trauma. Next, we're going to discuss how to be compensated for side effects of medications using secondary service connection. We're also going to discuss the VA Caregiver and Support Program. We'll do a quick review of the VA proposed regulation changes to the rating criteria for sleep apnea, tinnitus, and mental health conditions. And we're going to do some question and answers where we answer your questions that you've posted to CCK Law. Peterson. I'm a partner here at Chisholm Chisholm Kilpatrick, and today my co-host is Elise Phillips. Elise, tell us about yourself.
Yeah, so I'm Elise Phillips. I'm a supervising attorney here at Chisholm Chisholm Kilpatrick. I started working here in August 2016.
Wow.
So, yeah, it's been about 9 years now. For the first 6 of those years, I was working before the Court of Appeals for Veterans Claims, filing appeals of board denials. And then for the past 3 years, I've been working with our potential clients to look at their cases, apply the law, see how we can potentially maximize benefits for veterans and their families.
That's great. So before we get started on our topics today, be sure to like and subscribe, comment, and share. We want to hear your questions and feedback as we prepare content for the weeks to come. All right, so first we're going to discuss military sexual trauma, or MST, claims and how they're handled differently than other claims. So Congress and VA has made efforts to address the widespread underreporting of MST, or military sexual trauma. If you or someone you know experienced an MST, we're going to give some quick tips about how VA handles those claims, how the evidence rules differ compared to other claims for service connection, and support systems available to you or those who've suffered from an MST. Elise, why don't you give us a little bit of background about MST claims?
Yeah, sure. So just an overview, an MST is any sexual harassment or sexual assault that's happening to a service member unwillingly. So basically that could be any sexual activity where someone's either being forced to do something, threatened to do something, coerced, or where they can't consent to do something. It can happen on or off base. It can happen on or off duty. It can happen between any genders, and it can also happen, it doesn't have to just be between service members. So you could have an MST occur to you from someone who is not in service. Mm-hmm. And also the other thing that I want to talk about or just mention with the MST, because it can be a little bit confusing, is an MST is an act, right? So it's going to be the underlying thing that causes a diagnosed condition. It's not a diagnosed condition in itself. So if you do have an MST happen to you, that could lead to PTSD, could lead to anxiety, depression. All of these things are diagnosable conditions, and these are the things that would be service connectable by the VA.
Right. So since instances of MST are highly personal and sensitive, many assaults are not officially reported during active duty service. And due to underreporting, victims can find it really difficult to produce evidence in support of their claim for service connection. So as we all know by now, to get service connection for a disability, you need to have a diagnosis of a condition. You need to have an in-service incident or event, and it usually has to be documented somehow and a medical nexus between the two. And so that in-service incident or event is often not documented in cases of MST. But AZ versus Shinseki, which is one of the most seminal cases on MST, was actually argued by our colleague Zach Stoltz here at CCK, really was a game changer in the realm of MST. In that case, the U.S. Court of Appeals for the Federal Circuit explicitly held that the absence of service records documenting an alleged sexual assault of a veteran or a veteran's failure to report that assault cannot be used to show that the assault did not occur. So basically, longstanding principle, you can't show the absence of evidence as the substantive evidence that something didn't happen. So it's just unlikely, and these cases are underreported, it's not going to be very often that you'll find in a veteran's service medical records or service personnel records a documentation of the in-service assault. And so importantly, you don't have to in these specific cases under certain circumstances. So Elise, why don't you walk us through, how those evidence rules differ for MST claims?
So exactly as you said, Emma, usually when we're trying to show service connection, we're going to be looking for an in-service event or something that was an aggravating factor that happened in service. And as you said, usually we'll see that in the service records. But again, that they're underreported. Typically, you're not going to see evidence of an MST in service records. And if you do, it becomes a much easier case, frankly.
Of course.
So VA has recognized that both through AZ and also through regulation, which is 3.304 F5. That regulation has recognized that there can be certain what they call markers in service records or other documents. It doesn't have to just be records even, actually. That might show or support the fact that a MST occurred. So some examples of that, you might see someone requesting to change duty assignments or locations. Maybe there might be some significant work performance issues, a sudden shift in work performance. That would be something that would be documented in personnel records. Potentially, you might see someone start to abuse drugs or alcohol in a way that they had not before. There might be new anxiety that's starting to be documented in service records. Or you can even have buddy statements written either by friends, family, other fellow service members, people that noticed a shift in your behavior. These are all things that can support your statements that something occurred to you in service, specifically in MST.
That's right. And so that regulation you mentioned is specific to service connection for PTSD. And I think it's really important to note that because this doesn't necessarily apply, this relaxed evidence standard doesn't apply to service connection for other things that might be due to a military sexual trauma. All this to say, and it's specific to PTSD because to service connect PTSD, you have to have verification of a stressor.
Yeah.
And that's a little bit of an extra element compared to service connection for other conditions. But all this to say that it doesn't mean you can't use the typical sort of marker type evidence to prove your case for some other condition besides PTSD. Under 3.303D, anything that happens due to service should be service connected. So still get evidence the best you can if you're trying to develop a claim for a service connection for maybe depression, maybe you don't have PTSD, maybe you have anxiety, that's fine. You can still try to use this marker evidence. VA is familiar with what that means.
Yeah.
But be on the lookout because you might get someone who, really is a stickler and is like, well, this is not PTSD, so it doesn't apply. I don't think that's true. But in terms of that relaxed evidence standard for PTSD purposes, that's when you really can use the marker evidence to show that in-service stressor happened.
Absolutely. And sometimes we've even seen VA, they recognize markers, but they use the term almost too narrowly. They'll say, this isn't a marker, so there was no evidence of MST. But really, markers can be a lot of things. This is just a list of examples of things that it can be. So,
absolutely.
Don't get dissuaded if that's a finding that you see in a decision. One other point we wanted to make for MST victims is that VA facilities have designated MST coordinators. These are professionals that will help survivors assess treatment, navigate claims, and also find support. And also note that even if you're not service connected for your MST, VA still does offer MST-related health care, even before you have that service connected. So long as you're enrolled in VA healthcare, there are resources for you.
That's right. If you experience an MST, know that you're not alone. As we mentioned, it is really underreported, but every year the DoD has to put out numbers, and so you can take a look there if you're interested in how many MSTs are reported. But just know that you deserve justice and benefits just like any other veteran. And if you need help sorting things out, figuring out a strategy, please feel free to ask. Check out the blog posts we have on our website. We also have some other in-depth videos about this subject. We could talk for hours about this, but it is a highly sensitive and important subject to discuss. So I'm glad we were able to talk about some of the elements of MST service connection today. If you're taking medication for a service-connected condition and that medication causes some side effects, you might be able to get those side effects service-connected. How, you ask? By using secondary service connection. Just as a quick reminder, and we've talked about this a lot, so if you want a more in-depth discussion of secondary service connection, check out our other videos, but a disability that's either due to or aggravated by an already service-connected condition can also be service-connected, entitling you to additional compensation. So, medication you take for a service-connected condition causes something else, some other condition, you can get that other condition service-connected. So, Elise, what are some examples that you can think of, common examples that we see of our clients that get secondary service connection due to medications?
Yeah, like you said, we see this a lot. Medications that are necessary to treat disabilities, but they can also cause other conditions to arise. So, for example, sometimes with mental health medications, we might see GERD. We might see vision changes or decreases in vision. We might also see increased heart rates. Those can all lead to different service-connectable conditions. Another really common one is pain medications can lead to breathing problems, can lead to liver damage, cardiovascular problems, or other GI issues potentially. And cardiac medications can also lead to headaches, depression, GI issues, skin conditions. So it's not an exhaustive list, but it's just an example of how one totally different bodily condition can cause another bodily condition based on that link of the medication that you need to treat it.
Right. And it doesn't even necessarily have to directly cause it, right? So let's say you take a medication for depression or anxiety, and one of the side effects is GERD or other GI upset. If you already had GERD and this worsens it, that might entitle you to service connection for that condition. Same thing with, for example, a heart condition. If you already had hypertension or some sort of underlying heart condition, and the medication that's necessary, and we're not advocating go off your meds, not at all. Talk to your doctor. But if it makes it worse, you're entitled to get compensation for that additional increase in your disability level from VA. Some other interesting ways that you can get additional compensation from medication side effects is through special monthly compensation. So in that sense, we're thinking of, you mentioned loss of vision, for example. You could also have severe mobility impairment. I'm thinking, if someone has a really strong pain medication they have to take for an orthopedic condition, it might result in, a situation where they're unable to have the mobility they once did. Another example of that is someone who has to take chemotherapy for an active cancer. That can result in nerve damage to the legs. Maybe you have loss of use of your legs thereafter, entitling you to something called aid in attendance, or maybe just straight up loss of use, special monthly compensation level L. So it can do other things than just get an actual condition. It could be the impact it has on your life. And then that leads us to a common thing that we always discuss pretty much in every video, which is TDIU. You're taking medications due to service-connected conditions, and the side effects from those medications are so severe they prevent you from being able to work, prevent you from being able to secure and follow a substantially gainful job. You, in theory, could apply and be entitled to TDIU. So it's something to really pay attention to, depending on the medication you're taking, depending on the combination of medications you're taking for your service-connected conditions, you might be entitled to some extra compensation.
Absolutely. It's all part of that big disability picture.
That's right.
So one thing that we want to point out, though, to obtain secondary service connection based on the effects of medication, you are going to still need to show that you have that primary service-connected condition. So we'll use the example of a mental health condition. That needs to be service-connected. Then you're going to need to be able to show that you have a prescribed medication for that service-connected condition, which is now leading to this new condition. We'll say the vision changes. You, in order to do this, will likely need to get a medical nexus from a doctor. You're also likely going to need to have that secondary condition be officially diagnosed.
Yes. More than likely.
More than likely. It's very rare that you can actually get something service-connected that's not diagnosed in some very,
We're not going to go down that rabbit hole today. That's another video.
A totally different video. But some evidence you might want to gather that will help you get to this destination of secondary service connection. VA and private treatment records, anything that has your medication list and known side effects listed. imaging and labs that might show maybe if it's a nerve condition, maybe if it's hypertension or something like that. All of that's helpful. And lay statements, especially if we're talking about a worsening or an aggravation like we were mentioning before. Lay statements can go a long way to show that something that you once had is now worse thanks to whatever medication that you needed to treat your conditions.
Absolutely. So a medical condition that results from service, directly or indirectly, is eligible for compensation. We know this. We talk about this all the time. But don't be afraid to ask for help, especially talk to your doctor, talk to your treating provider who's prescribed this medication. They can probably give you some insight into how likely it is that your new health condition is caused or aggravated by your medication. And an experienced advocate might be able to assist you in identifying relevant records to putting together a claim for secondary service connection. So veteran caregivers have been getting a lot more attention recently, especially with the passage of the Elizabeth Dole Act earlier this year. So we wanted to do a quick segment on the Program of Comprehensive Assistance for Family Caregivers, PCAFC. It's a program that was launched in 2011 under the VA Mission Act. It supports family members who provide full-time care for injured veterans with benefits like a stipend paid directly to the caregiver, health insurance, and counseling. In 2025, VA announced that they were extending eligibility for legacy participants, so those already in the caregiver program, for their applicants and their family caregivers through September 30th, 2028. And that's really important because coverage was going to lapse for a bunch of folks as VA works out the process for transitioning people from the old criteria, legacy participants, to their new criteria they put out. So this will help these caregivers maintain their benefits for an extra 3 years as VA works on refining the program. So Elise, who is eligible for PCAFC?
Yeah, so there's some requirements for both the caregiver and for the veteran who's receiving the care. So first, with the caregiver, they must be over 18 years old and either a family member, so a spouse, a child, or a parent, or they can be somebody that's living with the veteran or willing to live with the veteran once the care starts. And they also must be designated by the veteran as either the primary or the secondary caregiver. Now, for the veterans, they must have, or they must be rated for a disability or a combination of disabilities at 70% or more. The disability that they need assistance for, care for, must be itself service-connected. So if you need, help for something that's not service-connected and you happen to have a 70% rating, you're not eligible. You must be service-connected for the issue that you need help for. And you also must need at least 6 months of help with personal care.
So after the caregiver applies, because again, this benefit it's obviously benefiting the veteran, but the actual financial part goes to the caregiver. So after the caregiver applies, VA assesses how much personal care the veteran needs. And so they're going to look at safety concerns. What memory issues are there? Is the veteran a fall risk? Is there suicidal ideation? They're going to look at lapses in awareness, situational awareness, any seizures, anything like that. They're going to examine, difficulties with life planning. Can you manage your medication or do you need assistance? Who's managing the finances? Who's dealing with the household tasks? Is the veteran participating or is it really all on the caregiver? Mental health symptoms play a huge effect in the level of care you might need. So if someone is, pretty severely impaired due to a service-connected mental health condition, they're having hallucinations, mood swings, aggressive behavior, that might indicate the level of care they need, sleep problems. And so really anything that kind of plays into what assistance you need with your personal day-to-day life, VA is going to take a look at. And so veterans are sorted thereafter into 3 different dependency levels, high, moderate, and low, based on how many hours of support the caregiver needs to provide to the veteran every week.
From there, primary caregiver benefits can include a monthly stipend that's going to vary, like you said, depending on the level. CHAMP VA health insurance, if they're not already covered, mental health counseling, respite care, which would be a minimum of 30 days per year, training and education in caregiving for the caregiver, and also travel benefits when they're accompanying a veteran to VA treatment.
And I think it goes without saying, but I don't think we really hit this. This program really is designed to compensate caregivers because they have to take a step back probably from their careers and their lives and their ability to earn a living to take care of the veteran. So all of this, the monthly stipend, the health insurance, the mental health counseling, all of these things are to help that caregiver be able to really give full-time care, almost as a job, to the veteran. And so that's why these benefits are so important and life-changing. But to apply, both the caregiver and the veteran have to fill out a VA form. We know VA loves their forms. It's 1010CG. And there's 3 ways to submit. You can submit it online at va.gov. You can mail it into the Evidence Intake Center. I would recommend doing online if you're able to. You can also go in person to your local VA medical center and connect with a caregiver support coordinator. But I really think your fastest bet, your most streamlined bet is probably going to be va.gov.
Yeah, I definitely agree with you there. After applying, VA is going to review your claim, and that's going to include a home visit to assess any environmental needs. It could potentially include a compensation and pension exam or a CMP exam, which we've talked about at length in other videos. Those would evaluate the functional needs of the veteran, not just the environmental needs at the house. And VA is also going to then assign the level of dependency. Like we said before, that's going to affect the stipend amount. Caregivers might also be asked to complete certain training modules. It's just going to depend on a case-by-case basis on that. But throughout the process, caregiver support coordinators through the VA will be available.
So VA's wrestled at times with implementation of this program. We have some other information about that. We have a pending court case about that you can read all about on our website. But it is a extremely important and sort of life-changing program for so many veterans and their caregivers who are benefiting from this program. So for more on the program, the benefits provided to caregivers, you can check out our website. We have some other articles there. One of our top videos in 2023 was an analysis of VA's proposed changes to the rating schedule for mental health conditions, for tinnitus, and for sleep apnea. And these changes would impact millions of claims. So there has been a lot of discussion about those diagnostic criteria rating changes. VA has in the past modified proposals based on public comment. So it'll be interesting to see what, if anything, they do here. So we're going to show a few clips of thoughts we had in 2023 and let you know what, if anything, has changed since then. And for the full video, you can check out the description below, and we'll link the video so you can get to it easily from here. So let's take a look.
On February 15th, VA announced some proposed changes to the VA schedule for rating disabilities, specifically pertaining to the rating systems for conditions within the respiratory, auditory, and mental disorder body systems. In particular, the changes are going to impact veterans seeking disability benefits for sleep apnea, tinnitus, and, like we mentioned before, those mental health conditions. According to VA, at least, these changes would incorporate medical advancements for treating certain disabilities and incorporating modern medical knowledge with the goal of more accurately compensating veterans for their conditions. It's important to note from the beginning that these changes are not going to impact veterans who are currently rated under the old system, and by and large, it won't affect veterans who have active claims pending. That being said, it could affect future claims, which is why we wanted to go over that information with you.
So it's been 3.5 years since VA proposed these changes. The first question everyone has right now, has VA announced the implementation date for these changes? Are we any closer to these being enacted?
We are not. Well, as of September 2025, the changes, there's been no implementation and no announcement as to when that will happen. We still do expect it to happen sometime in maybe late fall or winter of 2025 into 2026. But it's possible that this could get pushed into, summer or even later. It's hard to say. But one thing that we do know is that if and when these implementations do take place, there will be a 60-day notification window. So that's going to be a grace period where veterans will have time to basically get anything filed they want to file before the implementations take place. And that's super important because if you do file a claim before these implementations take place, then the more favorable version of the law will apply to you.
That's right. So if the old criteria is a better fit for your condition and you've been thinking about filing a claim for mental health condition for tinnitus, for sleep apnea, particularly for sleep apnea, you might want to get your claim in now. So here's another excerpt from our 2023 discussion.
Currently, if you have sleep apnea and your doctor has prescribed and you use a CPAP machine, you're going to get a 50% rating for that disability. That's irrespective of whether it helps your sleep apnea, you don't have any other symptoms or anything like that. But this is not going to be the case if these proposed rule changes, are final and actually become how they now rate sleep apnea. So with the proposed changes, a veteran would get a 0% rating for asymptomatic sleep apnea. So that's even if the symptoms are fully treated and asymptomatic because of use of a CPAP. So this is different than how the schedule works now. So then under the proposed change, the ratings would increase based on how symptomatic the condition remains after the treatment. So veterans would be able to get a rating of a 10% or higher only when the treatment is either ineffective or the veteran is unable to use the prescribed treatment due to a comorbid condition.
So over 2,000 people commented on this proposed reg change, most of it disagreeing with the proposal. But as we noted, there is no action to date from VA. But this is not surprising considering that right now you get a 50% rating if you have a CPAP that you need to use for service-connected sleep apnea, which can be a huge boost to a veteran's overall combined rating. So I am not surprised there's a lot of outcry about this proposed reg change.
Absolutely. That 50% really does help change a combined rating as far as VA math is concerned.
These proposed changes would not affect veterans who are currently receiving ratings for their tinnitus. But under the proposed schedule changes, veterans who are diagnosed with tinnitus would need to meet a higher standard, essentially, in order to receive levels of disability compensation, higher levels of disability compensation. VA officials have noted that these changes would likely reduce the number of veterans qualifying for disability ratings of 10% or more. Although this wouldn't affect veterans who are currently receiving those ratings, this is something that we see really commonly that veterans experience. And so it will be a significant shift if these proposed changes.
Yeah, so there's also been a lot of negative feedback on these changes as well, both from veterans and advocates. But there's no indication either way as to whether these critiques are really going to change VA's implementation or plans to implement these changes.
Absolutely.
So first and foremost, the new proposed rules for mental health conditions would increase the minimum disability rating from 0% to 10%. So it's no longer going to be possible to get a non-compensable rating for a mental health diagnosis. The rule would also get rid of a dated part of the schedule for rating disabilities that prevents a veteran from getting a 100% rating if they're able to work. There are plenty of veterans out there who are able to work in some capacity or another, but ultimately have such severe symptoms that they should be getting a scheduler 100% rating. But because they don't have total occupational impairment under the current diagnostic code, it just is completely ruled out for veterans like that. In addition to those changes, rather than assigning an evaluation based on the number and type of symptoms, VA is implementing a new set of criteria to evaluate mental disorders based on their impact, like we talked about before, and specifically that impact on 5 domains of impairment. Those new 5 domains are cognition, interpersonal interactions, relationships, task completion, life activities, and navigating environments, and finally self-care.
Okay, so the public reaction for the mental health proposals have been more nuanced than for sleep apnea and tinnitus. We've had heard a lot of anxiety from clients and from others that these changes might negatively impact them. But there's also some good arguments for how they could improve mental health ratings overall and access to care, because depending on your level of service connection, what you're rated at, you get maybe a better access to healthcare depending on that combined rating. So some of the more negative common complaints we've heard are, why make these changes now? This might end up making the process just more convoluted and complicated for veterans. It's complicated enough. Worries about compensation and pension exams, which we've talked about being not so great as of late. The new criteria might make it even all the more confusing for C&P examiners. And so, that's a real concern. However, we think it's likely that these changes could result in many veterans seeing ratings more accurately reflect their level of impairment and even over a higher rating than what they'd be assigned under the current mental health criteria. So we're just going to have to wait and see what VA does. I felt like we've expected these changes every year. Again, we're expecting them this fall or early next year, but you just don't know what VA is going to do until they announce that they're going to do it.
Absolutely. And it's kind of, in a way, it's a good thing that we have a bit of a warning that these things are a long lead up for this warning, because it's all the more reason just to get your claim filed now if you have one, if you have a viable claim. As we mentioned, whichever version is more beneficial to you would apply if you have your claim in before the changes take place.
That's right. So if you have any further questions about this topic, check out the video we link below. We have some other videos about these proposed changes and our website for more information. Welcome to the CCK Law Q&A segment, everyone's favorite segment. These questions were inspired by ones we've heard from clients, from commenters, and other practitioners. So remember that all these answers are for legal information purposes only. This is not legal advice. And we're going to try to keep things pretty high level. We're not going to get into the nitty gritty, citing regulations and policies to you. We want to really make this sort of digestible, easy to understand information, get those questions that you might have answered. And if you have more, please post them below and we will maybe get to your question next time. All right, Elise, start us off.
Yeah, so the first question is, can you address a question about retroactive pay? I'm due retroactive pay after being rated 100% P&T. VA wants to appoint a fiduciary before the funds are released, but it would have been months since I've been notified, and I have not been contacted by the fiduciary department. What are my options? Okay, so unfortunately, when VA just decide that a fiduciary is necessary, it's just a process that takes some time. But one thing that you can do to speed up the process is you can actually reach out to VA and submit a person that you would like to serve as your fiduciary. You don't have to just wait for them to appoint someone. You can reach out to them and say, this person can serve as my fiduciary. Fiduciary, just make sure it should be somebody that you trust, somebody that will distribute your funds appropriately and responsibly. But yeah, I would suggest that you reach out to VA to maybe speed that process along.
Yeah, typically a family member is a good choice, a spouse, a child, or a parent. We often see clients using those people. But like Elise said, you do not have to rely on VA's appointed fiduciary, and you can speed up that process by contacting them. All right. Next question. How do you get community care? My VA PCP says she has to approve it. Is there another way for it to get approved without my PCP's approval? So we just did a video on community care, and the short answer is no. You need to have a doctor or treating provider at VA approve that community care for you. Recently, though, VA got rid of the requirement of having a second approval necessary, so the process has sped up a little bit. But you can't just go out and get your own community care and then ask VA to pay for it. You do need to have approval from a doctor.
All right. Next one. In the legacy system, how long on average does it take for a remanded case that was returned to the board to be sent to a judge? So I'm going to assume that by sent back to a judge, you mean a board judge. So for a new board decision, on average, we are seeing it take approximately 6 to 8 months, but there's a lot of variables at play with remanded cases. So that can, that is an average. It can vary. But what I can say is that the legacy cases are remanding and going through and back to the board much quicker than the AMA cases.
That's right. And so I think, if that's like a board remand back to the regional office for development and back up to the board, that's plausible. We have seen some pretty quick turnarounds on cases coming back from court. So if it's a legacy case that was appealed to the Court of Appeals for Veterans Claims, and then it goes back to the Board of Veterans Appeals, sometimes that can be as quick as 3 to 4 months.
For sure.
It just depends on a number of factors, but it's going to take some time, unfortunately.
Yeah.
Okay, this actually leads into the next question. This is a great question. This is the age-old question, so get ready. It would be great if you could explain why it takes years for a case to be decided. If I could do that, I'd be a rich woman. One of my cases has been before a judge for 5 months. Why is it taking years, and how can we as veterans help? What letters can we write and to whom to make this process faster? Do we simply need more judges, or does the process need revamping? So great question. And I feel your pain. So the answer is multifactorial. There's a lot of things in play here. But here's some overall kind of high level nuggets of why it takes so long. So first, you have to remember that VA and the Board of Veterans Appeals is dealing with two systems. We have the legacy system and the Appeals Modernization Act system. So there's two separate appeal systems they're trying to work claims through simultaneously. And so just the sheer management of that can cause delays. And then in the AMA itself, when you get before the board, you have three different dockets to pick from. There's the hearing docket, there's the evidence docket, and the direct docket. And so how VA and the board is working those, it depends. And so for a while, they were working one docket, now they're on another. And so if they focus on one docket, put all their sort of efforts and personnel into that docket will clear out, but to the detriment of the other dockets. So that is another reason that these things can take so long. To your point about who can we write letters to, you can always write to your representative and your senator. That can't hurt. They do know the issues, though. This is an age-old question. Why is VA taking so long? But I think to your question, do we need more judges? Sure. You could always, brute force the problem. You could double the number of judges, double the number of attorneys working at the board. But just because you're getting more decisions doesn't mean you're getting more quality decisions or correct decisions.
Right.
So if you just throw a bunch of brand new people at the issue, you'll get more decisions, but is it going to be the right one? What you really want is a quality decision. And so sometimes it just takes time because the board member and their staff attorneys need to look at your file. Yeah. You don't want them just crushing through this the way the RO did maybe. You want them to take a look at your entire claim file. Look at all the evidence, think about the law, and actually get you the correct decision. So great question. Keep that question coming. We have to keep asking that question because we never want to get complacent and just say, well, this is what it is. Because there's always things that we can do as advocates and things that you can do as veterans to push the needle forward and hold VA accountable to make timely and accurate decisions.
Absolutely.
Okay, so we'll pick up there in the next podcast. If you have questions, please leave them below in the comments. Remember, do not provide any private or personal identifying information. We want to keep these as anonymous as possible, but we look forward to hearing what you have to ask. So, Lise, we've covered a lot of ground today. We talked about military sexual trauma. We talked about caregivers. We talked about proposed diagnostic code changes for sleep apnea, tinnitus, and mental health conditions. And so if you want to learn even more about these topics, we have a ton on our website. Please be sure to check out cck-law.com. Thanks for listening to us today on the Veterans Legal Lowdown. Be sure that you like and you subscribe and join our 100,000 followers on YouTube. And follow us wherever you get your podcasts. As always, make sure you take care of yourselves, take care of each other, and keep the fight alive.